teach this section to you a little bit different. This is a notice of dishonor section of the Negotiable Instruments Act of 1881 as amended in 1882, also identified as the Bill of Exchange Act. Now, in this example, we are now going to be looking at the bills that you are getting in the mail for, let's say, your wastewater sewage, your heat and electricity, your gas bill. Okay. Remember, at the beginning of this, a bill was a bill of exchange and still currently is a bill of exchange. And a note was a promissory note or a draft. Now, when you're getting these coupons or vouchers or bills, know that you can accept them and return them. And you're going to do an acceptance for value with honor, pay to the bearer, or pay to the order of, is how you can address these instruments that are being granted to you. Okay. And so it's very important that when we're looking at notice of dishonor, we're going to be looking at it a little bit differently. We're going to be looking at it in the aspect of receiving vouchers, coupons, bills. All right. So anywhere in the Negotiable Instrument Act where it says bill, know that they're talking about bills of exchange. Remember when we started out in volume 1, we talked about negotiable instruments and non-negotiable instruments. Well, the coupons and vouchers that you're getting for your wastewater electric bill or your gas bill or your heating and air bill are in fact negotiable instruments. And how we can properly identify that is that they do not say non-negotiable on them. Okay. So they're a bill of exchange that can be converted by your acceptance for value and returned, paid to the order of or paid to the bearer, and endorsement and putting the number in there. The vouchers and coupons you're getting are actually negotiable instruments. They're a check, ladies and gentlemen, believe it or not. And it's only due to our own ignorance that we pay 2 or 3 times most often. What I mean by that is your credit application was charged 75 years into the future. And so they've already gotten paid out of your trust once. Then the promissory note that went along with it, if in fact you signed anything to the sort, they got paid twice. And then the third time they got paid was out of your own ignorance, giving them Federal Reserve notes or checks or credits on account when they sent you the check, all right, or the coupon or the payment voucher. So we're going to go over how to negotiate your coupon or voucher or bill because it's a bill of exchange, all right? Notice of dishonor. 95. 1. Subject to this act, when a bill, your coupon, your voucher is sent to you, has been dishonored because you endorsed it properly, paid to the bearer, except for value with honor, by non-acceptance or by non-payment, notice of dishonor must be given to the drawer. Okay? When they sent that to you in the mail, they were the drawer of that instrument. All right? And now if they don't accept it, if you don't give them notice of dishonor, they will be discharged. And each endorser and any drawer or endorser to whom the notice is not given is discharged. Okay, so it's very important that we learn these things. Subsequent holder. Okay, when they mailed it to you, you became the holder. Where a bill is dishonored by non-acceptance, meaning that you may have received it in the mail, but your lack of action within 72 hours caused you to fall into dishonor, okay? By non-acceptance and notice of dishonor is not given, the rights of a holder in due course subsequent to the omission are not prejudiced by the omission. So where a bill is dishonored by non-acceptance, so when you send this back to them after it's been mailed to you and you properly endorse it, okay, and they don't accept it, and notice of dishonor is not given, the rights of a holder in due course subsequent to the omission are not prejudiced by the omission. Notice of subsequent dishonor. 3. Where a bill is dishonored by non-acceptance and due notice of dishonor is given, it is not necessary to give notice of a subsequent dishonor by non-payment unless the bill is accepted in a timely manner. In the meantime, notice up to acceptor. 4. In order to render the acceptor of a bill liable, it is not necessary that notice of dishonor be given to him. So you can still hold him liable. However, it's best to move forward with your notice of dishonor. Oh, excuse me, I misread that. Notice to acceptor. So you're the acceptor, you're receiving it in the mail. In order to render the acceptor of a bill liable, it is not necessary that notice of dishonor be given to him. Condition for validity of notice. 96. Notice of dishonor in order to be valid and effectual must be given A, not later than the judicial or business day next following the dishonoring of the bill, B, by or on behalf of the holder, or by or on behalf of the endorser, who at the time of giving notice is himself liable on the bill. C, in the case of the death, if known to the party giving notice of the drawer or endorser to a personal representative, if there is one, and with the exercise of reasonable diligence he can be found, and D, in case of two or more drawers or endorsers who are not partners to each of them unless one of them has authority to receive notice for the other. How notice given? 97. 1. Notice of dishonor may be given A, as soon as the bill is dishonored, B, to the party to whom notice is required to be given, or to his agent in that behalf. C, by an agent either in his own name or in the name of any party entitled to give notice, whether that party is his principal or not, or D, in writing or by personal communication and in any terms that identify the bill and intimate intimate that the bill has been dishonored by non-acceptance or non-payment. Misdescription. 2. A misdescription of the bill does not vitiate the notice unless the party to whom the notice is given is in fact misled thereby. Form of notice. 98. 1. In point of form, the return of a dishonored bill to the drawer or endorser is sufficient notice of dishonor, and a written notice need not be signed. Verbal supplement. 2. An insufficient written notice may be supplemented and validated by verbal communication. Notice by agent. 99.1. Where a bill, when dishonored, is in the hands of an agent, he may himself give notice to the parties liable on the bill, or he may give notice to his principal, in which case the principal, on receipt of the notice, has the same time for giving notice as if the agent had been an independent holder. Time for notice. 2. Where the agent gives notice to his principal, he must do so within the same time as if he were an independent holder. Notice to antecedent parties. 100. Where a party to a bill receives due notice of dishonor, he has, after the receipt of the notice, the same period of time for giving notice to antecedent parties that a holder has after dishonor. Benefit of notice. 101. A notice of dishonor ensures for the benefit A, of all subsequent holders and of all prior endorsers who have a right of recourse against the party to whom the notice is given, where given on behalf of the holder, and B, of the holder and all endorsers subsequent to the party to whom the notice is given, where given by or on behalf of an endorser entitled under this part to give notice. How notice addressed. 102. Notwithstanding anything in this act, notice of dishonor of any bill payable in Canada is sufficiently given if it is addressed in due time to any party to the bill entitled to the notice, at his customary address or place of residence, or at the place at which the bill is dated, unless any such party has, under his signature, designated another place, in which case the notice shall be sufficiently given if addressed to him in due time at the other place. Sufficiency of notice. 2. A notice referred to in subsection 1 shall be sufficient although the place of residence of such party is other than either of the places mentioned in that subsection, and shall be deemed to have been duly served and given for all purposes if it is deposited in any post office, with the postage paid thereon, at any time during the day on which presentment has been made, or on the next following judicial or business day. Death of party. 3. The notice referred to in subsection 1 is not valid by reason only of the fact that the party to whom it is addressed is dead. Miscarriage in post service. 103. Where a notice of dishonor is duly addressed and posted, as provided in section 102, the sender is deemed to have given due notice of dishonor, notwithstanding any miscarriage by the post office. Excuse for delay. 104. 1. Delay in giving notice of dishonor is excused where the delay is caused by circumstances beyond the control of the party giving notice and not imputable to his default, misconduct, or negligence. Diligence. 2. Where the cause of delay in giving notice of dishonor ceases to operate, the notice must be given with reasonable diligence. Notice dispensed with. 105. 1. Notice of dishonor is dispensed with A. When after the exercise of reasonable diligence, notice as required by this act cannot be given to or does not reach the drawer or endorser sought to be charged, or B. by waiver express or implied. Time of waiver. 2. Notice of dishonor may be waived before the time of giving notice has arrived or after the omission to give due notice. Dispensing with notice. Redrawer. 106. Notice of dishonor and dispensed with as regards to drawer where A. The drawer and drawee are the same person. B. The drawee is a fictitious person or a person not having capacity to contract. C. The drawer is the person to whom the bill is presented for payment. And D. The drawee or acceptor is, as between himself and the drawer, under no obligation to accept or pay the bill. Or E. The drawer has a countermanded payment. Dispensing with notice. Re-endorser. 107. Notice of the dishonor is dispensed with as regards the endorser where A. The drawee is a fictitious person or a person not having capacity to contract, and the endorser was aware of the fact at the time he endorsed the bill. B. The endorser is the person to whom the bill is presented for payment. Or C. The bill was accepted or made for his accommodation. Protest. Necessity of protest. 108. In order to render the acceptor of a bill liable, it is not necessary to protest it. Protest dispensed with. 109. Protest is dispensed with by any circumstance that would dispense with notice of dishonor. Delay excused. 110.1. Delay is not in noting or protesting is excused where the delay is caused by circumstances beyond the control of the holder and not imputable to his default, misconduct, or negligence. Diligence. 2. Where the cause of delay is noting or protesting ceases to operate, the bill must be noted or protested with reasonable diligence. Foreign bill non-acceptance. 111.1. Where a foreign bill appearing on the face of it to be such has been dishonored by non-acceptance, it must be duly protested for non-acceptance. Non-payment. 2. Where a foreign bill that has not been previously dishonored by non-acceptance is dishonored by non-payment, it must be duly protested for non-payment. Balance. 3. Where a foreign bill has been accepted only as to part, it must be protested as to the balance. Discharge. 4. Where a foreign bill is not protested as required by this section, the drawer and endorsers are discharged. Protest of inland bill. 112. Where an inland bill has been dishonored, it may, if the holder thinks fit, be noted and protested for non-acceptance or non-payment, as the case may be, but it is not necessary to note or protest an inland bill in order to have recourse against the drawer or endorsers. Protest unnecessary. 113. Where a bill does not on the face of it appear to be a foreign bill, protest thereof in case of dishonor is unnecessary. Subsequent protest for non-payment. 114. A bill that has been protested for non-acceptance, or a bill of which protest for non-acceptance has been waived, may be subsequently protested for non-payment. Protest for better security. 115. Where the acceptor of a bill suspends payment before it matures, the holder may cause the bill to be protested for better security against the drawer and endorsers. Acceptance for honor. 116. Where a dishonored bill has been accepted for honor under protest or contains a reference in case of need, it must be protested for non-payment before it is presented for payment to the acceptor for honor or referee in case of need. Protest for non-payment. 2. When a bill is dishonored by the acceptor for honor, it must be protested for non-payment by him. Noting equivalent to protest. 117. For the purposes of this act, where a bill is required to be protested within a specified time or before some further proceedings is taken, it is sufficient that the bill has been noted for protest before the expiration of the specified time or the taking of the proceeding. Protest on day of dishonor. 118. 1. Subject to this act, when a bill is protested, the protest must be made or noted on the day of its dishonor. Extending protest. 2. When a bill has been duly noted, the formal protest may be extended thereafter at any time as of the date of the noting. Protest on copy or particulars. 119. Where a bill is lost or destroyed or is wrongly or accidentally detained from the person entitled to hold it, or is accidentally retained in a place other than where payable, protest may be made on a copy or written particulars thereof. Place of protest. 120. A bill must be protested at the place where it is dishonored, or at some other place in Canada situated within 5 miles of the place of presentment and dishonor of the bill. Where bill returned by post. 2. When a bill is presented through the post office and returned by post dishonored, it may be protested at the place to which it is returned, not later than on the day of its return or the next judicial day. Time of protest. Every protest for dishonor, either for non-acceptance or non-payment, may be made on the day of the dishonor, and in case of non-acceptance, at any time after non-acceptance, and in case of non-payment, at any time after 3 o'clock in the afternoon, local time. Contents of protest. A protest must contain a copy of a bill, or the original bill may be annexed thereto, must be signed by the notary making it, and must specify A, the person at whose request the bill is protested, B, the place and date of protest, C, the cause or reason for protest, and D, the demand made and the answer given, if any, or the fact that the drawee or acceptor could not be found.